I want to bring Misty Marris back in, Zach Owen with us as well. Misty, John Mueller brings up an interesting point here. Does this raise the possibility that anyone and everyone who has been convicted via special counsel prosecution can now appeal those convictions? I mean, Hunter Biden, most immediate, but there are others.
Absolutely. So John brings up a great point, and I certainly think that that would be a legal avenue that would be pursued by those individuals, of course, because now at this juncture, there's a question about whether or not a special counsel falls under this idea of a superior officer or an inferior officer. And this is the argument that was raised. And it's all about what powers and the independence that that individual special counsel has from the DOJ, what oversight the DOJ has over that individual. And John made an excellent point that that's sort of, it doesn't make sense together, because the whole purpose is for the independent counsel or special counsel to truly act independently. But there's a test. There's a legal test that's now being hashed out by virtue of this argument and this decision. And so it opens up the door for further challenges in any instance where a special counsel has been appointed. And I would expect any lawyer, and of course, we're talking about Trump's lawyer now with respect to the DC case, and perhaps Hunter Biden's legal team, to raise that as a challenge, because as the canon decision, we see that everything's scrapped now, everything's on pause, everything's dismissed, all the motions are moot, because once that appointment is unconstitutional, anything that happens after that is completely out the window, because it falls under that. It's almost like fruits of the poisonous tree. It's gone because the appointment itself was not valid. So I would imagine we're going to see many legal challenges relating to special counsels in other instances.
John, it's hard not to connect this to other decisions recently, in particular the Supreme Court's immunity decision about an impression of lawlessness, right? I mean, at least lawlessness for former presidents, sitting presidents, people powerful enough. I'm just curious, if immunity has been defined so broadly as the Supreme Court did, and if you no longer have special counsels who can prosecute, well, whether they be presidents or the sons of presidents in the case of Hunter Biden or other public officials, where does that leave accountability for people in high office in this country?
Well, it raises an extraordinarily serious question. I mean, when you look at the history and culture of the concept of the special prosecutor, we go back to Leon Jaworski and the Watergate case and the evidence being developed against President Nixon that caused him to resign, in part with the promise of a pardon, which would end that steaming towards prosecution. But, you have the Kenneth Starr case against the Clintons, which went on literally for years and became not about whitewater and financial fraud that were alleged, but about President Clinton's affair with an intern. So we've seen the history of special prosecutors. Notably, in a related sense here, you have the case that Robert Mueller, the former FBI director, appointed as a special prosecutor to determine if there was Russian collusion in favor of Donald Trump during the 2017 election process, concluded that there wasn't. But in his report, which was basically in the form of a prosecution memo, it was indicated that a sitting president couldn't be prosecuted, but a former president could for any crime. So this just peels back a lot of layers. The question is, the next stop is going to be a court of appeals, and what happens to it there? Is this a short-lived ruling, or is this going to spin out over many months, as you said, all the way to the Supreme Court, as Misty said?
Misty, do you see any connection, no apparent legal connection between this and events over the weekend, attempted assassination, but perhaps timing to release this dismissal 48 hours, well, less than 48 hours, in fact, after the horrible events witnessed this weekend?
Absolutely horrible events this weekend. Look, there is no legal connection. Judge Cannon really doesn't have a time frame with which she's required to rule on any of these issues. But certainly the timing here on Monday morning was, I think, to me, a surprise when that breaking news came down that this decision had come out. But from a legal perspective, federal judges have a lot of leeway in the way they run their courtroom. And so there isn't necessarily an amount of time or days or limitations on how long a judge can contemplate and ultimately determine and make a ruling on any of these legal issues or the motions pending before the court. So no legal connection, but we can only opine that the timing is, it's obviously quite close in time to an unprecedented event.
Zach Owen, reading more from the decision here, Judge Cannon argues that the special counsel appointment, quote, usurps congressional powers. Reading here, if the political branches wish to grant the Attorney General power to appoint Special Counsel Smith to investigate and prosecute this action with the full powers of a United States Attorney, there is a valid means by which to do so. Is Judge Cannon making the argument that Congress would have to pass new legislation, in effect?
Jim, yeah, it's clear that in this order, Judge Cannon is challenging the executive branch's ability to appoint special counsels, and does say that in the recent past that the executive branch has used the special counsel, in her view, as sort of to appoint them on an ad hoc basis, basically whenever it politically suited them. Now, again, other courts have already weighed in and disagreed with Judge Cannon on that, but there is definitely an issue that she's raising here with the executive branch's ability and power to appoint special counsels, and she does seem to be suggesting that maybe it is the role of Congress. And it's also interesting because in this order, she does leave the door open for a path to potentially revive the documents case, though she does admit in this ruling that that is unlikely, and she doesn't really see how any resolution short of dismissal can apply. But she writes, for more than 18 months, Special Counsel Smith's investigation and prosecution has been financed by substantial funds drawn from the Treasury without statutory authorization, and to try to rewrite history at this point seems near impossible. She goes on to say the court has difficulty seeing how a remedy short of dismissal would cure the substantial separation of powers violation, but the answers are not entirely self-evident and the case law is not well developed. So again, she is raising this separation of powers issue and seems to be suggesting that Congress, with the power of the purse, maybe should have the authority to, impact these decisions, and that maybe the executive branch has overextended itself in its appointment of special counsels. Again, it's important to note that there are several other courts that have already weighed in and disagreed with Judge Cannon on this exact point. So it'll be interesting to see how the appeals process maybe clarifies this issue and whether it goes all the way to the U.S. Supreme Court in order to do so.
Misty, help me understand this, because I know if we talk about the Supreme Court, the conservative-led Supreme Court, they have often made this argument, well, this is really Congress's power. We're seeing that, for instance, with the Chevron decision, that agencies don't have this power. It's Congress. We saw that part of the justification for the Dobbs decision, that this is up to states, or Congress to legislate here. Although on the flip side, we see the Supreme Court grant the president enormous power, immunity from prosecution. Do you see any consistency here with that argument? I mean, does that fit that conservative view of Congress's power here?
Well, it's really all about breaking down that separation of powers and talking about where the court should not intervene and Congress has to act and pass a statute that would be on point with respect to any of those individual issues, Jim. And it's not the place of the court to stand in the shoes of the legislature. And so that's where we've seen those issues, and the Supreme Court punting it back down and saying, okay, well, if Congress wants to enact a law relating to any of these issues, then they can do so. But it's not for courts to really expand that power. And that's, again, with the executive branch. So it's the Supreme Court balancing where the judiciary, the legislature, and the executive branch have the ability to make those determinations. And oftentimes when it comes to issues relating to legislation, of course, that's supposed to go to Congress. So it just depends on the individual issues. But I think an interesting point was brought up specifically with this case, which is it's not necessarily that special counsels themselves are unconstitutional. It's just by the process by which someone should be appointed and what powers are bestowed. And should there be a statute, should there be legislation that allows for a special counsel to be appointed. And I think we are going to see this go to the Supreme Court, because oftentimes when there are circuit splits, that's when the cases go, when federal courts disagree and the Supreme Court clarifies those standards and moving forward, those will be the standards. And maybe it will be exactly as you said, Jim. Congress has to act in order for this to be constitutional.
John Miller, one could get the impression that a president or former president could take and hold classified documents, refuse multiple requests to return those documents, maybe even instruct staff to move it around and keep it out of the sight of cameras, etc. Attempt to overturn an election, both on a federal level and at the state level, and get away with it, but not even be credibly prosecuted for it. I mean, how do you fight that impression in the wake of a series of decisions over the last several months?
I don't know, because when you combine Judge Cannon's decision with the Supreme Court's decision about, well, a president can commit certain crimes, but it has to be whether it's on, government business or personal business, and where he's committing those crimes, took something that had been undisturbed and relatively clear, including presidential findings, to order the killing of Osama bin Laden and other terrorists that were well covered here, and cast a lot of that into doubt. But I think, to expand on what Misty was saying, this is a fundamental moment, because if we back into Judge Cannon's ruling, as Zach read it, you have the idea that the executive branch doesn't have the authority to create the special prosecutor and then fund them, that funding would have to be approved by Congress, which then gets us into, well, what would legislation look like, Jim? Would Congress also give itself the authority to appoint special prosecutors where they wanted investigations? Or, in a more likely scenario, if Congress got a petition from the Department of Justice to appoint a special prosecutor and said, we either approve that funding because we're interested in this investigation, or we don't approve that funding because we consider this what they now call lawfare, using the law as political warfare, this really cuts into the well-worn and long-standing independence of the Department of Justice to say what will be investigated, what won't be investigated, and by whom on the merits.
Yeah, and if the intent were to be to remove politics from the power to prosecute,
this
giving
would be
that power to Congress, I mean, would seem to, I don't know, turbocharge that, right? Given recent history.
I think it would. I defer to Misty on that, which is, it's such an interesting bridge to come to the beginning of.
Yeah. Misty, what are your thoughts?
Well, I'm grappling with the idea of how you have an independent counsel, or excuse me, a special counsel, and the inquiry is whether or not there is oversight by the DOJ. That was the whole focus of the trial, of the hearing that Judge Cannon held. Is this a superior officer or inferior officer? And the questions related to DOJ oversight. And so I grapple with the idea of, okay, so if we're saying a special counsel is appropriate when there's DOJ oversight, if we're saying that Congress has to have a role in whether or not a special counsel can proceed because of the financial component, then how can anybody ever be acting independently in that role? And that, to me, is where there's such a dichotomy, and it truly just doesn't make sense, because the idea of the special counsel is to act independently when there is a conflict of interest or when there's potential political motivations. So John, I think every point you made is absolutely spot on, but truthfully, I don't really know how that's solved by pulling Congress into it and by saying that officers are only appropriate if there's DOJ oversight. That doesn't really make sense.
Decisions with consequence. John, Misty, Zach, thanks so much to all three of you.